A federal judge in Washington, D.C. may have issued the most powerful order yet, criticizing Donald Trump for acting like a dictator, for acting like a king. Judge Beryl Howell, you may remember her name, as she was once the presiding judge in federal court in Washington, D.C., who would make a lot of grand jury rulings regarding the Trump criminal case when she was in that position. Well, she's back. She's a Washington, D.C. federal judge, so she really didn't go anywhere. But now cases are being filed in Washington, D.C., like this one filed by the National Labor Relations Board member Gwen Wilcox, who was fired by Donald Trump unlawfully and removed from the NLRB, the National Labor Relations Board, by Trump removing her. By the way, she was the first African-American woman to be on the NLRB, but by Trump removing her, he created a situation where they couldn't form a quorum. Thus, the NLRB would not be able to effectively function, a major win for corporations that are union-busting corporations, which are a lot of them, since you won't be able to actually take action if the NLRB can't meet. In any event, federal Judge Beryl Howell ruled that Trump's firing of NLRB member Gwen Wilcox was illegal. Beryl Howell said the following: a president who touts an image of himself as a king or a dictator, perhaps as his vision of effective leadership, fundamentally misapprehends the role of Article 2 of the U.S. Constitution. In our constitutional order, the president is tasked to be a conscientious custodian of the law, albeit an energetic one, to take care of effectuating his enumerated duties, including the laws enacted by Congress and as interpreted by the judiciary. And in the footnote 5, she's citing Donald Trump's social media post, where Trump says things like, "He who saves his country does not violate any law," among other statements that he's made. You know, her beginning of the order, too, even before that, she talks about this idea of the unitary executive theory and what it's about, and says what Trump's doing here goes well beyond that and simply is not consistent with the constitutional order of what the executive branch is supposed to do. This is what she says also on the beginning of her order. Scholars have long debated the degree to which the framers intended to consolidate executive power in the president. The unitary executive theory, the theory in its purest form, is that under our tripartite constitutional framework, executive power lodges in a single individual, the president, who may thus exercise complete control over all executive branch subordinates without interference by Congress, has been lauded by some as a hallmark of an energetic, politically accountable government, while rebuked by others as anti-American, a myth, and an invented history. Both sides of this debate raise valid concerns, but this is no mere academic exercise. The outcome of this debate has profound consequences for how we as Americans are governed. On the one hand, democratic principles militate against a headless fourth branch made up of politically unaccountable independent government entities that might become agents of corrupt factions or private interest groups instead of the voting public. Additionally, at least theoretically, empowering a president with absolute control over how the executive branch operates, including the power to, quote, clean house of federal employees, would promote efficient implementation of presidential policies and campaign promises that are responsive to the national electorate. On the other hand, the advantages of impartial, expert-driven decision-making and congressional checks on executive authority favor some agency independence from political changes in presidential administrations, with the concomitant benefits of stability, reliability, and moderation in government actions. No matter where these pros and cons may lead, the crucial question here is, what does the U.S. Constitution allow? To start, the framers made clear that no one in our system of government was meant to be a king, the president included, and not just in name only. Indeed, the very structure of our Constitution was designed to ensure no one branch of government had absolute power, despite the perceived inefficiencies, inevitable delays, and seemingly anti-democratic consequences that may flow from the checks and balances foundational to our constitutional system and governments. The Constitution provides guideposts to govern interbranch relations, but does not fully delineate the contours of executive power of the degree to which the other two branches may place checks on the president's executive laws. As present here, the Constitution does not even once mention removal of executive branch officers. The only process to end federal service provided in the Constitution is impeachment, applicable limited offices like judges and the president after burdensome political process. Then it goes on to talk about how here, in assessing the separation of powers, they go on to say it's not really a close call what Trump is doing here, regardless of what side you are on this debate. I wanted to read that all to everybody so they understood the thoughtfulness of this order, why it's such a big deal. Harry, what do you make of this order? Is it a big deal? And is she laying the foundation for something that's going to go to the Supreme Court?
So for sure on the issue, we have at least 3 different cases now, the National Labor Relations Board, and there are 2 others that are being litigated on this same issue. When you have an agency, a so-called independent agency that has more than one member at the top, can the Congress say the executive can't just fire them willy-nilly? And the law on that is clear. There's a case, a 90-year-old case that is on all fours, but everyone understands that the Supreme Court, not a district court, but the Supreme Court may well want to limit it. It had that principle that presidents can be impinged in their removal power, as she says, a concept that's not even in the Constitution, has long stuck in the craw of conservatives. But I think, Ben, you go right to what's really interesting about the opinion. And the part that's coming up, she says, oh, by the way, here's the law. Here's what district courts have to do. And it really is easy. So this thorough, really thoughtful and nuanced on the one hand, on the other hand, treatment that she begins with. And she had the same thing in the oral argument, a very fine lawyer on behalf of the fired NLRB member who said, Judge, they are taken out for a ride, this crazy theory that is not the law yet. She agreed and and it's related, of course, to the notion that Trump sees himself as a king. It's also related to the notion that is cross-cutting in so many of these cases, which is he thinks he can just ignore congressional commands. Congress set up this agency and said there's a measure of protection for the reasons that she spells out, right? For you want some impartiality, you want some expertise. We know that the Supreme Court, and it'll be closely watched at the time, may declare that that's an unconstitutional impingement on the executive's power. But by writing this opinion, she really sort of influences the whole landscape that's going to be, it might be 6 months, it might be a year. There'll be other courts that weigh in. As I say, the FLRA, the same thing is happening, the NLRB, one other, on this very issue. So she is A, educating the public, and B, very much kind of affecting the state of play of the law, and whether that whole first part is really, if you think about it, a way of evaluating should the Supreme Court actually cut away this principle that they've had for 90 years, even in the NLRB in cases where it seems to apply so well. So I think that is the part that stands out about the opinion. She could have easily not broken a sweat and just says it's still the law. Good night. If anyone wants to change that, see you at the Supreme Court. Instead, she took the trouble to explain, and I think to try to persuade the legal community, even potentially the Court of Appeals, which will review her opinion if it comes to that, and then possibly the U.S. Supreme Court. So I think, A, the point that she makes about you're not a king, and by the way, you have to listen to Congress, that was important for the decision and is cross-cutting. I love that footnote 5. But also B, she is going ahead and really explaining to us in a fair way. She says there, on the one hand, you worry about accountability. On the other, this one, but really setting out what's at stake in a case and an issue that the Supreme Court will be deciding, and is kind of arcane, but as she says, really means a lot for our day-to-day governance and whether agencies will be able to have some measure of insulation from just political winds that, Trump comes in and blows her out of there, no quorum, he doesn't care. This matters for us day to day. She really explains why. And, in that sense, it's an unusual and I think really an admirable opinion.
It's almost as if, Harry, she was writing what could be either an opening brief or respondent's brief to the Supreme Court.
Yes.
She's framing the issue in a clear way so that nobody could ever say, you're going to rule on what the issue is. Either Chief Justice Roberts, Amy Coney Barrett, because I think that's her audience right now.
That's everyone's audience now, right?
And then the 3 liberal justices.
Yeah.
Here's the issue. You gave this guy absolute immunity. Now you're going to actually make him a king. He's taking your absolute immunity and look what he's doing.
Yeah, right.
Or are you going to hold up, whether you're an originalist, a strict textualist, whatever, does to you being a conservative mean conserving the monarchy or conserving what's actually in our Constitution? Good luck. Good night. Here you go. That's how I read it. Harry Litman from the Talking Feds YouTube, Talking Feds Substack, and the Talking Feds podcast. It's where I get my legal news from. Everybody check it out. Harry, thank you so much.
Thank you, Ben. Talk to you soon. Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.